Patents provide incentives for innovation by providing exclusive rights of ideas which encourage research and development, stimulating innovations. Patent laws are the legal means to secure this technical knowledge, allowing patent holders to maintain this advantage. The idea of protecting innovations to provide an economic advantage is not new. In fact, it's widely accepted that it has been in practice as early as 500 BC in Greece and possibly earlier in Rome. Patent law is generally considered to have started in 1474 in Italy, with similar adaptations arising later in other countries. In its early days, the majority of inventors were individuals protecting their own ideas, or ideas developed working with small groups. Patent laws are covered by intellectual property rights and are governed by respective laws within different nations. Although there are arrangements in place for legislating intellectual property rights, such as the World Trade Organization's Agreement on Trade-Related Aspects of Intellectual Property Rights, legislation often varies slightly across nations. In general, however, in order to be awarded the protection offered by such laws, innovations must be new, non-obvious, and have industrial applications. With the advent of technological breakthroughs in telecommunications, computing, and the Internet over the past few decades, innovations today are often multidisciplinary and global, with innovators working together across geographic, disciplinary, and commercial boundaries. These days, we often see articles emerging regarding patent disputes, mainly between large corporations. It isn't uncommon to hear of costs and damages being awarded in the millions or even billions of dollars. Beneath these major battles popularized by media is an entire industry affected by just about every court decision made and every patent granted. In many cases, these disputes are settled without the need for the courts and are unknown to the world. Patents have been, and are still today being applied for and granted for fundamental aspects within standardization, trivial innovations, reinventions, and different uses for existing inventions, to name a few. The result of such applications being granted has triggered the growth in companies who specialize only in obtaining patents only to sell to, trade with, license, or even intimidate other companies. Companies today build their portfolio of patents as business tools for cross-licensing, as an insurance-type measure, or sometimes simply to eliminate competition within the market. Today, more so than ever before, the granting of patents is rising exponentially. The patent application process, however, has changed very little over these years, resulting in many patents being granted without rigorous testing or checking for existing patents. Great difficulties are encountered validating patent usefulness, as the limitless possibilities of technology allow for an infinite number of designs, algorithms, and components that alone are useless, yet can be very important for a larger purpose. As the law stands, people suffer greater liability if they had knowledge that they were infringing an existing patent. Today, the sheer volume of patents and the increased use of ambiguous wording has made it extremely difficult to identify existing patents. Further, pending patents are hidden from the public, making it impossible to search for all patents. Today's application of patents has demonstrated a fundamental flaw in the patent system itself, as more unwarranted patent applications are being granted. In an industry created and driven by the inventiveness and collaboration of many, the setting of standards, and the building upon these standards, the problems with the current patent system have significantly restricted the scope for innovation amongst the industry. There has been very little change in the patent system since the rise of the information age. The ethical dilemma regarding the patent system in technology has triggered major debates in the industry across the globe. We propose two solutions to this dilemma. The first solution deals with the lack of compatibility with the law, and second solution deals with the lack of regulation in the area of licensing. Solution 1. The industry needs to recognize a single global authority for reviewing and granting patents as well as handling disputes. This authority would consist of independent and recognized representatives from the respective industries formed as a single organization. Through empaneling member committees, the organization conducts a strict review of each application against the spirit of patents. Solution 2. Patent issuing authorities should be given complete control of what they issue. Once a patent is issued, the issuing authority manages and maintains all aspects of licensing and royalties. This would be an extension of the existing reasonable and non-discriminatory, or RAND, obligations set by standardization organizations to all patents. Having an independent authority management licensing would ensure the strict enforcement of RAND obligations without delay, allowing any company or person to make immediate use of any patent by purchasing licenses from this authority. Deontologist ethics would state that removing global inconsistencies and sharing knowledge for the future of the development would be morally right, and any actions denying or excluding this knowledge would be unethical. Utilitarian ethical theories would support such changes, as they would be of benefit to the majority, resulting in a greater distribution of happiness. Relativistic ethics would see both proposed solutions as a reasonable outcome considering today's complications arising from the current patent system.